Number 27, O'Brien versus the Port Authority of New York and New Jersey. Counsel.
Good afternoon, Your Honor. Christopher Simone for the defendant's appellants. I'd like to reserve 3 minutes for rebuttal.
Three, sir?
Yes.
You may.
This appeal calls upon this court to decide how to treat staircases under Labor Law 240 sub 1. As you know, a staircase is not an enumerated safety device, and the courts have been less than consistent about how to apply them. We propose that a workable rule should examine the staircase's function at the time of the accident.
So is that really whether or not it falls under those enumerated devices or what the hazard is?
I'm not
Because
sure I
if
understand
the
the question.
staircase collapses,
Right.
what would your result be?
Well,
Same facts you have here, except no rain, no slip. Plaintiff falls through the planking of the staircase. It collapses, and he falls to the ground.
I think the proposed rule that we're suggesting, that you accidents on staircases can give rise to a 240 claim when the worker's performing work from it, encompasses that. We're not saying that the worker doesn't have a cause of action for a fall.
Well, didn't we reject that argument in Nicometti? Didn't we say it didn't matter what they were actually engaged in doing at the moment of the accident?
Well, we're not speaking about the moment of the accident. We're not talking about the hammer stroke type of thing. We're talking about the general context of what's going on. For example, if I'm installing sheetrock on the side walls of a staircase, and I'm working from the staircase, but I should have been given a scaffold platform over it, then I wasn't provided with proper protection. But there may be situations where the staircase, if I'm not working from it, is the
But if in
appropriate device.
Nicometti you get off to go get a tool that you need to continue the work, Nicometti says that's covered. So why is this different? He went to get his raincoat to continue his work. What's the difference?
Well, because he wasn't working from, we're proposing that you had to be working from it as if it was a safety device. If another device should have been given, then it's just a staircase and using it as a passageway, not for
What
work.
if it's a staircase to get to a scaffold?
If it's part of the scaffold, I think that's a different situation, because there are scaffolds that have built-in stairs that aren't the same as this. But this is a significant staircase, and this was not, it's not a enumerated device, and it certainly could have been. It's not like staircases were.
So without
were a
the
mystery.
staircase, how is he going from one elevation to the lower elevation?
Well, in this case,
What's he
there
gonna
were-
do?
In this case, there were other staircases provided. There were internal staircases.
But there's still staircases, right? Let's say
Yes.
there are no staircases. How is he going to get from one to another? Isn't the point that he's got to have a device to get him from one elevation to a lower elevation? Isn't that the point?
Well, but you're just going from, using it as a passageway. You're going from, that's a reality of the job site, just like in Nicometti. You got to apply it logically. He had
But
a
if he's on the
staircase.
30th floor and he's got to get down to the 28th, you'd say that's still not a safety device? It has nothing to do with the construction site?
No, and
It's
we're
not
not
about
saying-
his safety moving from one elevation lower?
We're not suggesting that he shouldn't be safe, and we're not suggesting he doesn't have a cause of action, but the narrow issue is whether it applies it as a strict liability under 240 sub 1. That's the narrow issue here.
Nicometti was not a case where we said the stilts, I believe, right, in
Yeah,
that
stilts
case,
and then
were
he's
not a
defined.
safety device, right? We didn't find it was a 241 case, but we didn't say they weren't a safety device. But it seems like you want, in this case, for us to say staircase isn't a safety device.
What we propose is that you examine if the staircase, to determine if the staircase is a safety device, is what it was being used for at the time, and
But this-
whether a different device should have been provided.
But the stilts were being used to work on ceiling insulation, I believe.
Right, and they
So
didn't
how would
fail.
that fit with your rule?
Well, in Nicometti, the stilts never failed. He slipped on it. It was a different hazard that was at issue here, in that case.
It was the hazard, which
Right.
is, I think, where we started. So is it really that this isn't a safety device, but that it's the hazard that's encountered?
No, I mean, there could be different hazards on the stairs. In this case, it was
Right, like there could be
allegedly
different
water.
hazards on stilts, it seems to me. So it was ice, I believe, in Nicometti, but it wasn't because he was using stilts not for work or what he was doing on the stilts, and they're a safety device. It was the hazard he encountered.
But the stilts itself were the safety device, and nothing about them inherently anything was wrong with it. In this case, the issue is whether, if there's water or some substance on the staircase and you just slip on it, whether it's a 240 case, 240 sub 1.
Well, let me ask this. If there was water on a ladder, he's moving from one level to another, would you argue that 241 wouldn't apply?
No, I think because
How about a scaffold?
well, those are enumerated devices. The issue
No,
here is,
let me finish. But you would admit in those circumstances that that 241 would apply. That's pretty much what the case law says, right?
Yeah.
There's no question
If
on
it fits
that.
into the case law and
Right,
approximate
so
cause.
really, for us, then, it's a question of whether or not, and it goes back to, I think, your cross motion, whether or not this staircase, this temporary staircase, is the functional equivalent of a ladder or a scaffold, right?
Yeah, and as we said in our brief, I don't think there's really a necessary distinction between temporary and permanent. In fact, this staircase was here for a long time.
You're going far afield here on this case. If you want to go, you want to say there's temporary staircases don't apply now either?
Well, no, I think staircases, I don't think it matters
I
whether
see.
it's temporary. or
Because the rule is permanent staircases, not 241.
But not consistently. But
So,
not
so if they had a
consistently.
ladder instead,
Well,
would
that's
it be
an
covered?
That's a enumerated device. I think that if there's something wrong with it and it fits into 240, then yes, then it would be.
But you're not explaining, I think, apropos of what Judge Fahey is suggesting here, you're not explaining how, other than it's not listed, and of course, the list is not exhaustive, is it? You're not arguing the list is exhaustive? No. So if it functions just like a ladder, and you've now conceded that a ladder would have been a safety device, why isn't this staircase a safety device?
Because
In
it
fact,
isn't-
isn't it more safe than a ladder, given the circumstances of this case?
I think staircases are safer than ladders, and I think that's the appropriate device. So I think you need to examine it.
Yeah, but that's why they draw the temporary and permanent distinction. And it's funny, because when you look at this, the steps themselves, in many ways, look closer to a ladder than a staircase.
Well, they're made of steel, but they're deep, like a staircase.
In-
And temporary,
All right.
I'm not sure how,
Are
how
you
you apply
making an
that.
argument, a Nicometti-type argument, that the water isn't the risk, that a safety device is being used for?
That was not raised in the motion at all. But
Okay,
certainly-
so that's not your argument?
No, that's not an argument we raised. That wasn't raised below, and we didn't change the argument on appeal.
How about on the 241-6 argument? I thought that of course, that wouldn't really affect you, would it, at this
Well,
point?
241.6 is still a viable issue here. It's
Yeah.
still an issue, and even though we had moved to dismiss plaintiff's argument on that, we proposed that there were certainly issues of fact on that, numerous issues of fact. that would
Am I
preclude summary
correct
judgment.
that you would argue that the water on the staircase was not rain, but simply a foreign, it was rain, which is simply a foreign substance and not covered under 241-6?
Well, I think 241.6, I think the code says water. I
Right.
believe it says water. So, and again,
So
Plaintiff could
I
have
got it
deposited-
right, just so I got it right. So your argument is that rain isn't water?
rain isn't water?
Yeah, explain your argument to me on this, because maybe I'm
On the
misunderstanding.
241.6?
Yeah. Water,
We're saying there's issues of fact on that.
right.
That's our.
Rain is simply a foreign substance. It's not water. That's your 241-6 argument.
No, I don't.
Okay.
Our argument is that there's issues of fact that precluded whether there was even a violation because it hadn't rained for 4 hours. He could have deposited himself. There's certainly issues of comparative fault. He's fond of saying that everybody knew it was wet, but then use the other staircase or be more careful. So I think that the Appellate Division
Well,
got that right.
those are straightforward comparative arguments,
Yeah,
so.
well, and also whether it was a lack of reasonable care. There's 3 parts to a 241.6 claim, not just 2. Not just a violation. You have to show notice, you have to show that the violation was a lack of reasonable care, because the violation of a code is just some evidence of negligence.
Sure.
Thank
Thank
you,
you
sir.
very much.
Counsel,
Good afternoon, Your Honor.
good afternoon.
My name is David Perisman, and I represent the plaintiff. This is my associate, Peter Riegelhaupt. I hope if I need him, you'll allow him to pass me something if I need it. I think there are 3 questions here. I don't really think they're questions, but there's 3 issues. Number 1, is it a 240 device? I think all the questions that you just asked sort of answered that. Clearly, it's a 240 device. It's a functional equivalent of a ladder. Can't get up and down without it. The second issue that they brought up was whether the activity that he was doing at the time, which was going to get his raincoat, is covered, and Judge Stein, you covered that adequately in Nicometti. You said it would be illogical if doing, at 1 second you're doing this and another second you're doing that, we turn off the labor law. The third issue is only the question of whether there's a question of fact. And for that, we get into a more fact-intensive approach.
Well, why isn't there a question of fact? You got one expert who says the staircase doesn't meet industry standards, the steps are slippery, the nubs are worn, and the other expert says it meets industry standards, there's nothing wrong with the nubs that you can tell from the photos, and that's all you have available. Why doesn't that then boil down to one expert against the other, and that
Well,
can't be resolved
Two
on
reasons.
summary judgment?
Several reasons. First of all, if you look closely at what the expert says for the defendant, all he keeps saying is it meets industry standards, it meets industry standards. And this court was very clear in Zimmer when they said the industry does not get to set the standards. We set the standards. Secondly, if it violates NYCRR 23-1.7, which it clearly violates, it's either a foreign substance or it's water, and it was on the stairs, they permitted them to use it, it violates OSHA, which doesn't allow
Staying
it.
on the 241, the absolute liability issue. If one expert is saying the anti-slip measure is the nubs, and those aren't enough under these circumstances, and they're worn, and the other expert says they're enough and they're not worn, why isn't that a question that
Number
cannot
one-
be resolved on summary judgment?
Number one is the water. Mr. Glabe never addresses the question of water. And there's no question from the records. Every record said it was raining that day. Even the defendant, DCM, one of the subcontractors, my client's employer, said in their report.
Well, how is that? And I'm a little confused by what you mean by that. The defendant's expert is saying there are these holes for the water to drain, and then you've got these raised metal nubs that provide traction. How is he not addressing the question of whether or not these steps are slippery?
Well, he may say they provide traction, but the question is, were they adequate?
And it seems to
And
me...
apparently they proved inadequate.
It seems to me the proved inadequate, though, at the appellate division is he fell. And we've said pretty clearly that that's not the standard.
I don't think if my client just tripped and fell down a perfectly good set of stairs that are neither narrow and steep, and they are narrow and steep, neither worn nor wet, steel and wet, that would be another question.
I think other than steel and wet, I think Judge Rivera's getting to is those initial issues are questions of fact. But to go back to an issue that your adversary may have conceded, what about the idea that if this is a safety device, the hazard, this was in Nicometti, where it clearly was a safety device, is not one contemplated by the statute, that this is a slip and fall?
Every single department, including cases from this court, have acknowledged that slippery surfaces can be what causes a 240 case. I think in Nicometti, there was a reference to Striegel, and in Striegel, they spoke about ice on the roof when he slipped down the roof, and ice on a scaffold.
But Nicometti, the plaintiff is clearly what is categorized as a safety device. He's on stilts, and as I understand the case, slips on ice while on stilts. And we say in that case, and while he's working to install, I think, insulation, and we say in that case, this is not the type of hazard contemplated by this very different type of scaffolding statute. So how is this different than ice on the floor, water on the stairs?
Because in Nicometti, the ice was a wholly separate hazard. The ice was over here, the stilts were there.
But then the
Here-
stilts go on the ice.
Well, that's why
Like the rain goes
That's
on
why
the
I
stair.
thought Nicometti was a placement case, but aside from that, the court held it's a wholly separate hazard, and I believe that was the rationale for the holding. This is not
The court
ice
said
somewhere else.
This is an ordinary workplace hazard, so the question is ice, is water more similar to ice?
But in this case, the water's on the stairs, and those
So-
stairs become slippery, and they know they become slippery, and the reason
So
you know...
are you saying that this is like metal scaffolds that when it's raining are slippery, and if you're working on the scaffold, you're gonna slip? 'Cause they're
Absolutely.
just slippery, so you need something other than just the metal.
And we have acknowledgement of it in the record. We have the regulation.
Okay, but point then is that you have one expert who says what these steps have to dress with the slippery aspect of metal and wet metal, in this particular case, are these raised nubs, and of course the holes for the water to go through. And the other expert says, yes, and that's enough. Isn't that then, again, a question that you cannot resolve on summary judgment?
I think if you read his affidavit closely,
He being who in that? I'm sorry.
Glabe, their expert, he never says they're enough. What he says is they meet industry standards. In other words, this is what they provide on sites.
Counsel, wouldn't your argument also be the same no matter what the device would be if there's an accident? Because you said it was obviously inadequate. The steel and stairs were obviously inadequate because Mr. O'Brien fell.
Well, he slipped and fell, and there's no question that it was raining that day. In fact, the defendant in their accident
But you're saying
report...
if it had been a trip and fall, we wouldn't be here? Is that
If
what
he
you're
had
saying?
tripped on his own 2 feet on an otherwise adequate stair, we would not be here.
What if the soles of, somehow the soles of his shoes were worn, or maybe somebody had just walked down those stairs with a glass of water and there was a little bit of water on the stair and he slipped on that? I mean, would we be saying that no matter what happens, if you're going downstairs?
I'm not asking the court to say no matter what happens, but when it's raining all day long, and when you have defendants, as they did here, who admit, we work in the rain, we have no procedures from stopping people from working in the rain, and the very people who supplied the scaffold testified that they do become worn, they do get, when they get wet, they're outdoors,
But isn't there
and they
at
do
least-
get slippery when they're
Is there a
wet.
question of fact as to whether these were worn? One expert says, you can't tell that from the photos, and the other one says,
Well,
never saw the stairs, but based
he
on the
actually
photos.
went a little further. What their expert actually said is they can't get worn from people's boots. However, the person who supplied the scaffold, who's a defendant in this case, said the exact opposite. And
But why isn't that a question of fact?
because you can't just say something in an affidavit and it gets accepted because you said it. Because there's not a single staircase that you're going to walk down.
But isn't that what happened with the plaintiff's expert with the majority in the first department? Didn't they accept what the plaintiff's expert said?
I think what they did was look at the defendant's expert's affidavit and realized that he didn't say anything. All he kept saying is it meets industry standards. He never once said, I took a scaffold, when they're wet, they're not slippery. It's not in his affidavit. Neither did he say they weren't worn. He said they're designed not to wear down. On the other hand, we have the supplier of the scaffold who says they do,
So
and who may just.
Is your position, though, that this is defective or malfunctions because it's wet? In other words, if it had not been raining that day, totally sunny, and hadn't rained for 3 days, right? Hadn't rained for 3 days, that on its face is nothing wrong with this staircase. Is that your position?
I think it would be a tougher case.
Why so?
Because then it's hard to tell from the photographs the degree to which they're wet.
Well, wouldn't it be
However,
harder?
in the
wouldn't-
first-
No, my hypothetical is they're not wet.
I'm
Not
sorry,
wet at
the degree
all.
to which they're worn, it's hard to tell from the photographs. But here, we don't have that circumstance. We know they're narrow, we know they're steep, they're tiny little stairs. The whole thing is 30 inches wide. It's metal. They have no procedures from keeping you out of the rain. And there are 3 different places that talk about not using stairs. OSHA, in fact, says slippery conditions on stairways shall be eliminated before the stairways are used to reach other levels. Period. End of sentence. It's 29 CFR.
So why then does the majority say plaintiff is entitled to summary judgment, whatever the weather conditions might have been?
Because I think they're going based on a prior decision that they held in a case called CRIMI, C-R-I-M-I, where they said that the mere narrow and steep nature of the stairs was enough. And I would
They don't
Be-
cite that case, and they don't refer to that anywhere. This
That's-
is in the context of talking about the plaintiff's expert's opinion in his affidavit.
They don't cite Crimmy, but I believe that's the basis of it. It was argued at the oral argument, I know that, and it doesn't matter here. This is unquestionably wet, and there's no question that weather, water, and elevation devices are a problem. If this was a ladder that was wet, no one would be asking me, I don't think, these questions.
So
Does
your position is, the real question is this a covered device? Because if the conditions were the same in an inarguably covered device, one that was listed, then we wouldn't be discussing this at all.
Correct.
Does-
That's what I think, and
Does it matter that he says that when the plaintiff, that when he takes the first step, his foot is landing on the tread, and this is where the plaintiff's expert is talking about the treads also being worn? Does that matter?
I
It's on
don't,
the tread where what, right on the nose, I'm sorry, on the nose.
I don't think it does, but what the defendant's expert said was that the depth of these stairs, which are 9 3/4 inches, are sufficient to tread upon the stairs without putting your foot on the edge. First of all,
He didn't say he did that. He said.
No, he put his
nobody
foot-
cer- He put his foot on the edge.
where everybody else puts their foot, and
But
that's
that's my
why,
point, does that make it somehow
No.
different that he's doing that and that he
No.
says that's worn and the expert is saying that's worn?
that's the way every human being goes downstairs, especially if you're a big guy like my client. And my foot is a foot long, and I'm not big. I'm sure we could take judicial notice of
I
that.
guess my point is, if the anti-slip property is worn at the tread where he puts his foot, regardless of whether or not the anti-slip property isn't worn elsewhere on the step, that he's got a claim.
Inadequate.
Thank you, counsel. Mr. Simone?
Sorry. A couple of quick points. It wasn't raining at the time of this accident. In fact, it had stopped raining more than 4 hours ago, and there was never been a concession that there was rain. In fact, in our opposition to the 241-6, one of the issues we said is he could have deposited the water himself on his own feet. So, and even the appellate division,
Are you saying the steps weren't wet? That
I'm
there's a
saying that-
factual issue about whether or not the steps were wet?
well, yes, I think there is a factual issue, and that the appellate division itself found there's an issue of notice. Notice of what? What condition? For purposes of the 240 issue.
So if the
we're-
steps are wet, is it defective? Does he have a claim?
Not necessarily. I mean, things get wet. You know, we're not the insurers of safety, and that's well-settled proposition. And accidents can happen under the, even the safest of conditions.
But isn't his point that if you've got wet steps that don't have effective friction or traction measures, that is not a safety device? Maybe you could have had something else. Maybe you could have blocked off the staircase so no one uses it.
I think
But
that-
that in and of itself is the violation.
It's difficult to envision a greater battle of the experts than here about that, on that issue. I mean, plaintiff's expert didn't give any specifics. Our expert measured the steps, said what was on them. I mean, that's...
But he is correct that the expert's affidavit from the defendant's side, both of those affidavits are relying on industry standards. I mean, the plaintiff does too, don't get me wrong, but on the defendant's expert's
Well, I think
affidavits, it's always about these steps and this staircase meets industry standards.
I think that's part of the issue as well. It's also a 241-6
But we've
case.
rejected industry standards, right?
That's true, but it's still,
But that's not
relevant
gonna
to
be a
show that.
basis.
I think it's still relevant to show that this is a state-of-the-art staircase.
Well, if the whole industry is using something that's not appropriate under the law, it's not going to matter, right? That's the point of it.
I don't think there's any...
So other than that,
Deluge
what
of
else
cases
is
based on these.
where else is that factual dispute? Is it about the nubs? Is that what this
The
boils
issue
down
is
to?
whether it was proper protection. I think there's a big dispute on that, whether it's proper protection. And
Whether the
and the appellate
staircase is
division...
proper protection, or whether there's proper protection that is available otherwise.
Well, that could be part of it. I think the jury can decide whether there was proper protection under these circumstances. If it is a 240 device. If it's not, then he's relegated to a 241-6, which we're saying...
But aren't you arguing that even if there isn't a better safety device, tough luck, this is what they get at the work site?
No.
Right? I mean, if there isn't, and this is not a proper safety device, you just can't use it. Isn't that the answer under the labor law?
Well, I don't think that's this case, Judge. There are other staircases
But
available
would
never
that
issued.
be the appropriate interpretation of the statute?
I'm not sure I understand.
That even if you're arguing there's not a better safety device, that's not what matters. What matters is whether this is a safety device.
Well, that's the first issue, is whether it's a 240 device. It's still a staircase, and he still
Every judge
has the
who
right to
looked
be
at-
safe.
You said that in your opening argument, counsel, and every judge who's looked at this said it was a safety device, yes?
Well, even the dissent said that.
Right.
We're saying that if you look at the case law, there was a time when it's been inconsistent. There was a time when, no, it wasn't considered an enumerated device based on whether it was being used as a passageway. We're saying you've got to look at what was being used for at the time to decide if it was a device under 240, a
Well,
structure.
even under the dissent's view that it was a safety device, the dissent found there was an issue of fact about
Correct.
whether it was adequate.
But we're saying it wasn't a safety device because it wasn't being worked from, and that's what we believe the statewide test should be to give some consistency. And the appellate division's decision
Well,
clearly,
you're saying it was a passageway, right?
he was using it as a passageway. There are circumstances,
I'm
I
just
think-
quoting from your brief. You said a passageway from one place to work to another. That's the core of your argument,
Well, his
right?
work was on a different level. He was just getting a
No,
check.
is that the core of your argument?
Yes, he was using it as a passageway, but
Okay.
our position is the test should be, examine its function at the time. There may be certain times when working from the stairs may be the right thing. A person who's installing carpet is not going to be working from a scaffold. But someone who's installing sheetrock above a stairs maybe they should be given a scaffold, in which case they weren't given proper protection.
But
Because
we
staircases are
don't
tricky.
apply that analysis to a ladder, though, do we?
A ladder is an enumerated device. I think it's a different.
Well, I know, but if we say stairs are a safety device, then we're including that, we're analogizing that to ladders.
But
aren't we?
stairs, I think, are excluded for a reason, because stairs are nothing, they're commonplace. They're in homes, they're in buildings, you don't normally picture them as a safety.
Of course,
device.
that's why we draw the temporary permanent distinction.
Right.
Right.
But I think, that's even a misnomer in some respects, because this staircase was there for years. Is that temporary? I mean, I think it should be safe under the circumstances regardless of
The
how long it's
construction
there.
site is there for years, the risk is there for years. I mean, that, I don't know.
Well, this
that's
staircase was there for a year
Making
after.
your point, right?
It was
That's
there
not
for a year
necessarily
after.
making your point.
Yeah.
Thank you, counsel.
Thank you very much.